Okay, we've got two major developments in the trial of Derek Chauvin, the police officer accused of killing George Floyd when he kneeled on his neck for approximately 8 minutes. The video went viral. The trial is major national news. I'm sure you've heard of it, but if not, we'll talk about it in a minute. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator here on YouTube. If you like this stuff, hit that subscribe button, hit the notification bell. Don't miss any videos. It's important. Okay, so let's talk about this. Derek Chauvin is a police officer, along with three others, who is accused of killing George Floyd. This killing sparked, and mind you, killing is the proper term. I'm not calling it a murder or anything else. That's something that this trial is attempting to determine. This killing sparked nationwide demonstrations, a literal firestorm, as cities were lit on fire by mostly peaceful protesters who also engaged in various acts of destruction and violence that didn't involve fire. So it has been a mess. This was a pervasive story throughout 2020, and this was the proverbial spark that lit the fuse. Was this officer involved death of George Floyd? Now, a lot of stuff has happened since that fateful day, and a lot of evidence and questions and arguments have come out about George Floyd. This video is not intended to address whether or not Derek Chauvin is guilty of killing George Floyd. There are lots of questions people have about the amount of fentanyl in his system, about various excited sort of responses that people can have to a police apprehension that can send them into shock or cardiac arrest. There's all kinds of questions, and whether or not Derek Chauvin is at fault is something for the trial. That's the whole purpose. So I know many of you will have opinions about this both ways. Put those aside for just a minute, and let's talk about something that isn't involving the guilt or innocence of Chauvin at a principle level. All right? So jury selection has been going on. I think they only have one seat left to fill. The jury selection has been going very, very quickly, although it encountered a hiccup the other day, which I was going to report on, but now I'll incorporate it into this, in that two jurors were dismissed after the city announced a record-setting settlement for George Floyd's family. The city, prior to any trial, either civilly or criminally, determined that the city was at fault for George Floyd's death and settled for $27 million to the family. Well, that, of course, made major national news, and some of the jurors did see that news story. So they had to bring the jurors back in and ask them about this news story and ask them whether or not that would impact their ability to be impartial in the case. And a couple jurors said, yeah, I can't do it. I got to go. I can't be impartial. Basically confirming that the settlement made them think that Chauvin was guilty, is the inference on that one. But so they said, okay, thank you for telling us you can't be impartial, or that you can't be impartial. Get out. We don't need you here. So then they filled those seats. They got one seat left to fill. And the other jurors were presented with the story, and they said either they hadn't heard it, they could ignore the story. No, you can't, but okay, they said it, so they're still in, and apparently the court believed them. But that prompted, first of all, the questioning of jurors. The next thing it prompted was a request from the defense attorney to go ahead and either delay or move the trial. And that's what we're going to start with here in the article. A judge overseeing the trial of Derek Chauvin, who is charged in George Floyd's death, ruled Friday that the former Minneapolis police officer's trial location will not be moved or delayed. And this is a big one. The question has been from the start, can Derek Chauvin, and it's, for some people, it's really hard to remember that right now, Derek Chauvin is the one who needs to have the presumption of innocence. I mean, you can presume innocence or guilt against George Floyd. He's not on trial. You can make personal opinions about him. As far as the law goes, they're concerned whether or not Derek Chauvin is guilty or not, and he is presumed innocent. So the question is, can Chauvin get a fair trial in the city of Minneapolis? A lot of people mix this up, and they wonder if Floyd, even though he's not on trial, if Floyd can get a fair shake in the city of Minneapolis. Floyd's not entitled to any fair shake. That's a harsh reality of the criminal justice world, but Floyd is deceased. And since he is deceased, he's not entitled to much protection at all as far as his guilt, innocence, participation. What they can't do is they can't try and bring up Floyd's character either way to influence this trial of Chauvin, because Chauvin's rights are the ones that the state needs to be interested in protecting. If Chauvin is not granted a fair trial and is found guilty because someone venerated George Floyd, for example, and the jury's like, oh, yes, the man was a saint, now Chauvin must be guilty because we hate him, then he's actually going to get that conviction overturned or have a mistrial declared or whatever. And so the state has to be extremely careful. So the question has been, can Derek Chauvin get a fair trial in Minneapolis? Many people say no. I'm guessing I'm going to see a bunch of comments in the description that say no, not a chance. But the judge disagrees. It's a tough one because they are going through this very rigorous jury selection with the ability to strike jurors for both sides. And so that is presumably able to weed out the unfairness, but that's a question that's a little more philosophical. Hennepin County Judge Peter Cahill on Friday denied a defense request to postpone Chauvin's trial after a $27 million settlement from Floyd's family, for Floyd's family, raised concern about a tainted jury. Cahill also partially granted a defense motion, ruling that his 2019 arrest can be included in the trial, but on a limited basis. This is the other major development in that they're going to be able to use evidence from this May 6, 2019 arrest of Floyd, in which he acted in a very similar way, including calling out for mom, including saying he couldn't breathe, including potentially swallowing drugs that might have been on his person. That's all part of that 2019 arrest record. Now, the judge had previously said they could not include it, and here's why. This is Rule of Evidence 404, and then we're going to look at Subsection B. Evidence of another crime, wrong, or act is not admissible to prove the character of a person in order to show action in conformity therewith. So you can't use that 2019 arrest to show that George Floyd does this on purpose, which is weird. That's definitely, by the way, the defense's strategy. The defense absolutely wants to show George Floyd's 2019 arrest to show that he acts this way consistently, and that they also want to show that he's a bad guy. That is, if you listen to the internet and their mutterings about George Floyd, typically it involves the fact that he was convicted of armed robbery years ago, something that probably will not be admitted at trial, and that he has drug addiction or drug problems, and that he was on these drugs at the time of the arrest. And it is a question of character of George Floyd. And that is fine for the internet. That is not fine for court. And so the judge has said they can include details of this arrest. We're going to read from the article in just a second, a little more detail about it, but they cannot use it to show his actions and the intentionality of his actions. They can't do it in that way. And they cannot include that he cried out for mom the same way. And I don't think they can include the drugs, but it's in the article here. We'll get into it. But I just want to point out there's a rule about this, and that rule is to protect witnesses. It's to protect defendants from being prejudiced. That's the whole point, from being prejudiced by the court, not from their own prejudices. So, okay, Chauvin has been charged with murder and manslaughter in the May 25th, 2020 death of Floyd. In moments captured on video by a bystander, he was seen pressing his knee against Floyd's neck for about 9 minutes, and his subsequent death set off weeks of protests. Blah, blah, blah. They were violent, sometimes violent protests. They were violent protests. Can we just get around this? Can we please stop pretending that no violence occurred? Tons of violence occurred. Tons of businesses will never recover from it. It's been a mess. It's a disaster. And it covered the entire nation because people do not have any respect for the court process or anything like that anymore. And so people are mad. People are mad and they make bad choices. Okay. So as for a change of venue, this is what the judge says about change of venue. I do not think that would give the defendant any kind of a fair trial beyond what we're doing here today. I disagree. The defense disagrees, but whatever. I don't think there's any place in the state of Minnesota that has not been subject to extreme amounts of publicity on this case. That's not the issue here. That's not the issue in regards to the settlement. Part of the issue in regards to settlement is that Keith Ellison is the Attorney General of Minnesota, who is technically the lead prosecutor on the case, even though it's being tried by someone else. And his office's involvement has raised questions, especially when I believe his son is on the Minneapolis City Council that approved the $27 million settlement. So when you've got the direct relatives, there are questions about whether or not this case is being prosecuted fairly. I don't think the city of Minneapolis is a proper venue. I think they should move it outside the city. There are numerous large secure courthouses outside of the Twin Cities that could handle a case like this. And I think it would be good to remove it from the potential violent protests that are right there in proximity and would threaten jurors. But that's my opinion. Judge Cahill denies. He denies this. He says, no, it's going to be the same no matter where it is. I doubt it. He denied similar motions last year. So that's consistent. Now, he has changed on this one, the issue of Floyd's 2019 arrest. He previously denied the defense's attempt to allow the year-old arrest at trial, but he heard fresh arguments this week because of drugs found in January in a second search of the police SUV in which the 4 officers attempted to put Floyd in 2020. So they're saying there were some drugs found in the SUV where they were trying to put him, and those drugs may be linked to George Floyd. Of course, it's a police cruiser, and they put various defendants in there. They may not be as well, but that was enough for them to say, let's take a second look at this prior arrest. And I guess the judge agreed with that. So Nelson also argued that similarities between the encounters are relevant. Floyd calling out for his mother, claiming he'd been shot before, crying and putting what appeared to be pills in his mouth. Nelson said there were similarities between both incidents and that the evidence is relevant to the cause of Floyd's death, which is in dispute. And there are some, I don't know that those are sufficient to overcome the rule in its entirety, and the judge agrees. The judge says not all of it can be admitted. So Cahill says it can only be used as an example of Mr. Floyd's bodily reaction, his physical symptoms upon being confronted in almost the exact situation. But his emotional behavior, calling out for his mother, is not going to be allowed. And that is probably consistent with the rule. That's the thing with rules of evidence, is they exist in absolutes, but cases aren't, they never present in absolutes. And so the question is, how do you get around these various limitations if it's relevant to the case? So they've got some of it in there, his bodily reaction and his physical symptoms. So crying, potentially having a heightened heart rate or stiffening up. I don't know what exact symptoms they're going to look to introduce, but that is what's going to be admitted. So it's a partial win for the defense here. They have not gotten their full request. And to be honest, I don't think they should get it on this issue. Mr. Floyd's reactions in 2019 are not, in my opinion, really relevant to whether or not Chauvin caused Floyd's death. Those are different things. Now, if Floyd were on trial for resisting arrest, maybe those actions become more and more relevant. I don't know. That's not the case here. Question is, did Derek Chauvin cause the death of George Floyd? Him crying, him calling out for his mother, that stuff is not necessary. That doesn't have anything to do with how he perhaps died here, be it a fentanyl overdose, an excited reaction, or some sort of traumatic reaction to the knee. That's what the trial is for. And I don't think his behavior there in 2019 has anything to do with that. Now, there could be a possibility of admitting this evidence depending on how the trial goes. If the defense tries to use some sort of other thing, maybe Chauvin's reaction or something like that, maybe there's an opportunity to get this evidence in later if it becomes relevant, if they come up with some sort of theory as to why it's relevant in relation to the trial. They can petition for it again, and we'll see at that time. But right now, that's where it is. So, brief recap, and then we'll wrap up the video. No change of venue. No delay in the trial. Jury is almost done. There's like one seat left. 2 jurors were dismissed because of the $27 million settlement. And finally, evidence of the 2019 arrest of Floyd will be admitted in a limited capacity to show that Floyd reacts in a particular way, that his body, not his mind, that's the difference. They can't prove the character. They can prove the response. So his body responds in a particular way to arrests, and if the defense will be able to use that to their advantage, great. But they will not be able to do anything involving his emotionality, his character, those sort of non-bodily responses will not be included. So this is huge news. It's a split bag for the defense. It's partly a win. It's partly a loss. They really wanted to change venues, and I think the venue should be changed. I really do. I didn't think the judge would do it, but I think it should be done. I don't think that he can get a fair trial in Minneapolis. And right now, no matter your opinions of Floyd or Chauvin or anybody, he is the defendant and the state is the state, and the defendant is entitled to a presumption of innocence, and the defendant is entitled to all the rights and protections that can be given to it against the state, guaranteed under the Constitution. I don't think he gets a fair trial in the city of Minneapolis. And if he's convicted, I'm sure that's going to be a big question. But let me know what you think down in the comments. I would love to see, and we'll talk soon. Peace. Peace.